honestly feel so bad for this lady. I feel like this incident is just unfair. But who am I to challenge this? This has been decided by the High Court. What am I talking about? I'm talking about Miss Andrews, the Indian lady whose health and care worker visa has been revoked and now she's being deported back to her country just because of a simple misinterpretation of the UK immigration rules. And this could have happened to any of us. Like, it could have happened to me, and you will understand why later. This video, I'm going to dissect exactly what happened to this lady and lessons we can learn from this lady's story based on the High Court order and what happened at the High Court when this lady applied for judicial review. So if you're interested, stay tuned. Stop that. Hi guys, welcome once again to my channel. My name is Nanel Griselda, and on this channel I talk about nursing, I talk about migration, I talk about opportunities for people to relocate abroad and life in the UK as an immigrant in general. So if these are topics that interest you, please consider subscribing. Today I'm talking about Miss Andrews, an Indian lady who came to the UK around 8th of June 2023, and only 20 days later an incident happened that changed her life. On the 28th of June 2023, immigration enforcement officers, observed that Miss Andrews, although she came on a health and care worker visa, was seen behind the counter at a convenience store serving people. So it was like she was at a shop, offering services to people. People pick, their milk, their bread, their chocolate, and then Miss Andrews is the one serving them at the counter, taking their money and giving them a change. When they asked for, what kind of visa are you on, who are you, do you have even legal permission to be in the UK? Because mind you, the immigration enforcement officers, they do random checks at places. They can even go to Scotland, and these videos are all over on YouTube. They can just raid a warehouse and then they'll just ask for, all the non-British people, show us your proof of residence in the UK. They do that all the time. Right. This lady, when she was asked the kind of visa she was on, blah, 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 she said that, well, she is on a health and care worker visa. She came on 8th of June 2023, and she is just helping at this shop, and she's just doing voluntary work. And somebody might say, why is this even an issue? So when you come to the UK on a skilled worker visa, so let's say you come as a nurse, you come as a carer, you come as a doctor, you come as an accountant, an IT personnel, you are giving, once your visa is issued, they give you a letter as well, and they give you your biometric residence permit, when you come to the UK. This was before e-visas and all of that. On the BRP, or on the biometric residence permit on the card, you see what is on as restricted work. Now, what does this restricted work mean anyway? So when they indicate restricted work, obviously it means that your work in the UK is restricted to the main sponsor, the company that brought you to the UK. You are only allowed to work in a job that falls in the scope of that job for which you were granted the visa. They do this so that you don't abuse your sponsor. So I remember back in the day when I came to the UK at the time, right, 2019 thereabout, I felt like being a carer was cool, right? And then I felt like it was less mentally stressful. So I thought I'll pick extra shifts as a carer in another company, right? And somebody told me it's not allowed and that you can only do the job. At the time, it was very clear on the website that with the same occupation code, right? Later on, when COVID happened and they were, short and all of that of healthcare professional, they relaxed that rule a bit. So restricted work basically means that you are restricted only to work for the employer that gave you the sponsorship, and you can only work in a job that falls within the scope of the visa. And as well, even when you want to take an extra job, you can only work maximum 20 hours a week for a different employer, but it should be under the same job role. You understand? So a nurse will pick an agency shift, but the agency shifts you're allowed to do maximum 20 hours a week for this new employer. And then you can also do unpaid voluntary work. So obviously this lady came to work as a carer, and you are now seen at a shop attending to customers. Obviously these are two different jobs. You cannot be working there. So she did say that, oh, my visa allows me to do unpaid voluntary work, and that's what I'm doing. I'm not being paid, I'm only helping out in this store. And you thought that was actually a very smart response, and that was actually a very good response in my opinion. However, her visa has been cancelled, she's being deported, she has to go back. Why? Now listen, let's read exactly what it says on the gov.uk website. It says, taking on additional work. If you work overtime in the job you're being sponsored for, you do not need to update your visa. So if you're, let's say, NHS and you're picking a lot of overtime in the NHS, you don't need to update your visa. There's no limit on how many hours of overtime you can do. So now that has been clarified. There's no limit to the amount of overtime you can do for your sponsor. You can also work 20 hours a week in another job or for your own business, as long as you're still doing the job that you're being sponsored for. Your work must be in an eligible occupation code. And then they explained what eligible occupation code is. And then they said, you can also do unpaid voluntary work. So remember, the rules are simple. You should be working for your main employer. You can do as many overtime shifts for your main employer. You can also do 20 hours a week in another job or for your own business, as long as you're still doing the job you're being sponsored for. And your work should be in an eligible occupation code, and you can also do unpaid voluntary work. So these are the rules. Simple, or so we thought. And then they are saying that if you're doing more than 20 hours a week in another job, you will need to apply to update your visa so that you are being sponsored to do both jobs. You need to get a new certificate of sponsorship from your second employer. You need to include a letter with your application explaining that you want to change your current permission to stay. So this lady, the reason why the High Court decided and handed down their sentence just on the 17th of January this year. So now this lady says what she was doing was just voluntary work. So how come her visa has been cancelled? So now this is what the High Court said on the 17th of January 2025 in regards to this lady's case. They're saying that you cannot rely solely on the Home Office guidance, which does not carry the same legal authority as the statutory provisions or the immigration rules. So basically, they are just trying to say that when it comes to immigration rules, immigration policies, we have immigration rules, we have Home Office guidance. And at any point in time, you should make sure that you are following the immigration rules. If you're just basically reading and taking what it means, voluntary work for it based on the guidance, because what I just read to you is just a guidance. But they're saying that there is something that is much higher than the guidance that you always have to refer to. And that is the immigration rules. So immigration rules are sort of like the detailed rules and regulations and the policies, and the guidance in this case appears to be sort of like a summary to help just the general public understand. But if you want the in totos, if you want the details, if you want the explanation detailed, you have to always fall back on the immigration rules. So now sometimes this has made us understand that sometimes just reading something just plainly on a gov.uk website, sometimes it has a much deeper meaning, and until you consult the immigration rules which explains and details exactly what they mean, just taking that word just by voluntary work can land you in trouble. So this is how the court defined voluntary work. So according to the immigration rules, this is what voluntary work really is. But when you open the gov.uk website and you read on taking up additional work, it doesn't really explain exactly what voluntary work is. You have to go back to the big book, the rules, to get the actual meaning of what they mean by voluntary work. So apparently this is what they mean by voluntary work. Now let me read verbatim so I don't make a mistake. So the court clarified that voluntary work, as referred in the guidance, must align with the definition in the immigration rules. So like I said, we have guidance and we have immigration rules. The immigration rules is what your case will be decided on if you should go to court. Is the highest of it all. Don't just read the guidance and say, okay, that's it. Refer back to immigration rules because that is more superior. So now they said voluntary work is defined in the immigration rules as having the same meaning as applies to a voluntary worker in the National Minimum Wage Act of 1988. Section 44 of the National Minimum Wage Act 1998 provides, amongst other things, 1. A worker employed by a charity, a voluntary organization, or an associated fundraising body or a statutory body does not qualify for the minimum wage in respect of the employment he receives under the terms of his employment. Apart from this act, is entitled to 1. No monetary payment of any description or no monetary payments except in respect of expenses actually incurred in the performance of his duties or reasonably estimated as likely to be or have been so incurred, and no benefit in kind of any description or no benefit in kind other than the provision of some or all of his subsistence or of such accommodation as is reasonable in the circumstances of employment. So simply put, what they are saying is that in the immigration rules, what a voluntary work means is a work that is being done for a charity, a work that is being done for some voluntary organization or a fundraising body or a statutory body for which you are not being paid. Okay, even if you are paid, it is just cost incurred doing that job. So let's say during COVID, at the time I wasn't married, I didn't have a child. I mean, when COVID actually happened, like in the early days of COVID, and I used to see adverts of people advertising for, this ambulance company, right? It's a private ambulance. It's sort of like a charity ambulance service organization, right? And they were looking for nurses and other people who just want to help, because, COVID. And I was really thinking of, because I really admire paramedics, their job and all of that. So at the time I was in a nursing home and I wanted to. So I was not going to be paid. And for that case, let's say I took a taxi to where I have to go and join the ambulance, and I was paid for that transport fare. That possibly could have, falling under this voluntary work they're talking about, because it was a charity or it was a voluntary organization. But working in a convenience store is not a charity. This convenience store is not a charity. They are not generating any money to help, underprivileged or whatever. It's somebody's own benefits job, right? And also, it's not a voluntary organization. And even though you say you're not being paid, it doesn't fall under these ones. So it is not considered to be a voluntary work. So that means you are breaching the immigration rules of your visa. So that means you are at fault and you have to go back home. So these are the key takeaways in this particular story. And there are 3 of them that I'll talk about. So one, there's what we call legal hierarchy. So the court has made it very clear that there's what we call a legal hierarchy in terms of immigration matters. So you always have to make sure that to know exactly what the immigration rule means over what the Home Office guidance is. So obviously now when you're checking, you have to type what the immigration rule says and not just what the Home Office guidance says. Now we all have to understand what they mean by voluntary work. So now if you're doing any other job, you're not being paid, or you're just helping out a friend or a family member, and you think once you're caught, you're going to say it's voluntary work. Now we know exactly how the Home Office interprets voluntary work. Is that company you're working for a charity organization or a voluntary organization? Is it registered as a charity? If not, then I'm very sorry, you can't be found wanting. Now we've clearly understood that there's a conflict between immigration rules and immigration guidance, but remember, the rules are superior to the guidance. But most of the time when you Google something, it's the guidance that comes. So make sure you dig deeper, or make sure you subscribe to my channel so that I give an explanation, right? But what I didn't see was that I didn't see anywhere, or maybe if you know of this, just comment below, that said that she was not working for her main employer. I didn't see anything like that. I didn't see anything that said that she had done anything otherwise. Maybe she came and she has not gone to see her main sponsor, So this is quite painful, and it could have happened to anybody. I mean, now I understand why. Early in the days when I consulted RCN immigration advisory team about my YouTube channel, that does it fall? Am I allowed to do it? Does it fall? And I thought it was just a hobby, but I'm just being paid for it. Will that land me in trouble? The lady bluntly told me, stop once you get your ILR. And I think I've shared this in a video, and I've even gone deeper in another video on my community page. Now I understand this can happen to anybody. What does the immigration rule say? Always consult the immigration rule first. Miss Andrews, I'm very sorry, especially because this happened to you just 20 days after you landed in the UK. And for people who have come to the UK, and let's say your sponsor lied to you, and now they have no shifts and they have no opportunities for you. So now you also cannot stay broke, so you have to go and look for another job. Make sure that other job you're finding immediately grants you a certificate of sponsorship so that you can switch employers. Because if you are caught working for a different employer who is not your main employer, and that person has automatically become your main employer, that can land you in trouble. Honestly, I think that these days they want to cut down on immigration, so the least thing is an opportunity for them. So let's be careful. If you have any other contribution to this story, let me know in the comment section. Thank you so much for watching. Bye.